But it was in the Marbury case that Marshall gave the Supreme Court and the judiciary more generally its most important role. In the majority opinion that Marshall authored, he explained that although he believed the Jefferson administration was acting shamefully in not delivering Marbury his commission to be a justice of the peace in the District of Columbia, the court did not have the authority to issue a writ of mandamus to order Jefferson to deliver the commission. The whole case was based on this guy, Marbury, who was, I guess, a Maryland businessman and politico. He'd been given one of the midnight appointments by John Adams as a justice of the peace. That was one of the ones that Adams issued on his way out the door, although it was never actually delivered to him. And once the people in the Jefferson administration discovered that it wasn't delivered, they just kind of held on to it and didn't give it to him, though it had been signed and though a seal had been affixed to it. Marshall went through the whole decision and found that, yes, Marbury should have gotten his commission. That, yes, he should seek some legal remedy to get his commission delivered. That, yes, his rights had been violated because he did not get his commission. But Marshall said that it was not in the jurisdiction of the Supreme Court to make a decision like this and deliver a writ of mandamus to give Marbury his commission. Marshall declared that the portion of the Judiciary Act of 1789 that granted the Supreme Court the power to issue writs of mandamus was unconstitutional. Congress didn't have the authority to change the jurisdiction of the court as was laid out in Section 3 of the Constitution. So Marshall is saying that the Judiciary Act of 1789, at least a portion of it, gave authority to the Supreme Court that the Supreme Court should not have, according to Article 3 of the Constitution.